Alright, Part 5 Federal Law Affecting Real Estate. Fair Housing Law, Chapter 20, Essential Matters to Learn in this chapter that increases the real estate salesperson personal knowledge of observance, civil rights law of important create equity, equality in home, equality and housing opportunity with equality proportion question of the topic that has been increased with the real estate license examined in recent years. Over the question is not merely asked what the law is, but instead how it is be applied with a given fact pattern. Important equal opportunity housing compelling leads equal opportunity education jobs other important matters. Federal Housing Act of 1968 is part of the Civil Rights Act of 1968. Fair housing is amended with significant in 1980 has been modified since. Protected classes based on race, color, religion, sex, national origin, family status, including pregnant women and the families of the children under 18 or handicapped. Fair housing law prohibited discrimination practice. All real estate brokers build with the mortgage lenders serving the protected class. Real estate appraisals may not describe the racial composition neighborhood within the subject house exists. For example, if a real estate asked by the owner to take a listing of the house, but not to show the house for the members of a certain race, but the broker should refuse the listing, since the broker should treat everyone the same to purchase the lease of opportunities. It is unlawful for the organization with the other membership of the real estate service provider to decline the offer of the membership of the protected class. Nearly all the dwelling units covered in the federal housing law, dwelling units is defined in the structure, either the residence of one or more families, condominium, and co-op, mobile home park, trailer court, or time-sharing units. Refusing to rent and sell of the discriminating type in terms of rent and sale of advertising preference, failing representation availability of the unit, including housing changing mark because the entry and by protected classes are unlawful. Handicap includes persons physically impaired, alcoholics are covered. However, drug addicts, persons convicted of drug-related felonies, and transversities are not. Handicapped persons who seek the lease for the dwelling must pay the lesser cost of the change needed, the wheelchair ramp, grab bars, and bathroom. Most restore the property when vacated. The person who requires a serve of the dog may keep it at even level with the dogs. Otherwise, it's not allowed in the complex. Most repair animal damage when vacating. Central terms to understanding steering is directing a certain class toward or away from a certain racial ethnic area. Blockbusting, attempting the profit by announcing neighborhood over the entry of a certain class. Redlining, refusing to financing housing a certain neighborhood. There are notable exemptions for housing law. Housing elderly only, where 100% of units are occupied by resident agents 62 80 or older, whereas 80% of the units are occupied by at least one person 55 or older. Of the housing publisher adheres policy that demonstrates the intent to serve the people over 55 and over. Apartment complex, four or few units of the owner occupies at least one single family housing sold rented by an owner which owns more than three properties. The exemption that is not available to own advertised using discriminate language as exclusive whites only when the service of the real estate broker is used. A church that owns rental housing may require the tenants and the members, as long as the church does not discriminate based on race, color, sex, national origin, familial status, and handicap. Private clubs are provided lodging and incident for their purpose may be preferential lodging treatment of the members. New housing development, multiple stories only, ground floor units must be accommodated with a handicap. Owners and lessors may refuse seller to lease someone who is not economically qualified to purchase the rent. An aggravated person may file complaint with the Department of Housing Urban Development within 1 year of alleged discrimination practice. The person may file civil action before the district court with 1 year of the alleged violation. Americans with Disability Act passed in 1992 does not apply to single-family housing intended to eliminate physical barriers, prevent disabled workers or customers from functioning in the marketplace. Federal Fair Housing Act, Public Law 9284 were enacted in law April 11, 1968 as Title 8 of the Civil Rights Act 1968. Significant amendment occurred in 1988. Other changes haven't been passed since. Our Purpose of Fair Housing Act. Purpose of the Fair Housing Act, except in Section 801 of the law, which states any policy of the United States provide with a constitutional limitation of fair housing throughout the United States. Following exemptions of any of the housing with a quoted directive of the Understanding of the Fair Housing U.S. Commission on Civil Rights. Housing key important financial families' economic condition. However, the home ownership is one of the important ways in which America is traditionally required with the financial capital to take advantage of the accumulation of equity, increased value of the real estate property, and enable homeowners to build economic assets assets. Assets can be used to educate one's children to take advantage of business opportunity to meet financial emergency, provided retirement. Nearly two of every three majority group programs are homeowners, but less than 2 of every 5 non-white families other than own their homes. Consequently, the majority of non-white families are deprived of this advantage. Home housing essentially securing civil rights in the other areas suggests segregated residential patterns in metropolitan areas undermine efforts to assume equal opportunity, equal education, while standards of employment have been moved to central city suburbs, outlying parts of the metropolitan areas. Minority groups remain confined in central cities because they are confined. They are separated from the employment opportunities despite the variety of laws against the job. Discrimination lacks access to housing, closing proximity, available jobs is an effective barrier to equal employment. In addition, lack of equal housing opportunity decreases respect for the equal education opportunity. The controversy over the school busing is closely tied to the residential patterns of the cities and metropolitan areas. If the school's large urban centers are desegregated, transportation must be provided to convey children for segregated neighborhoods and integrated schools. Finally, racial division are to be bridged. Equal housing, essential settlement, other on one. Our city and metropolitans are consist of separate societies, increasing hostile, distrustful of one another because of the minority and majority group holders live apart with the strangers to each other. By living in this neighborhood, there would be an opportunity to learn to understand each other and redeem the promise of America that one nation individual. Discrimination in sale or rental. Section 804 Fair Housing Act makes it unlawful to do any of the following: refuse to sell rent after making a bona fide offer, to refuse to negotiate in the first sale or rent, otherwise make an unavailable or deny dwelling to any person because of race, color, religion, sex, national origin, family status, or handicap. B, to discriminate against any person with the term, condition, privileges, sale, or rental dwelling, provision, services, faculties, facilities in connection with the race, color, religion, sex, national origin, family status, or handicap. C, to make a prank put cause of the may be dependent to publish any notice, settlements, and advertisement with respect to sale, rental dwellings, indicate by the performance limitation, discrimination based on race, color, religion, national origin, family status, handicap, intention to make the such personal limitation description. D, to represent any person who, because of race, color, religion, sex, national origin, familial status, handicap of the dwelling, available to inspect, sale, and rental of the dwelling, in fact, is so available. For profit to induce, attempt to reduce any person to the rent of the dwelling of the representation regarding the entry of the perspective of the entry into the neighborhood of the person, particular race, color, religion, national origin, family status, of the handicap. 1988 amendments today, nearly all the dwelling units are subject to the Fair Housing Act. Amendment of the Federal Fair Housing Act became law in 1980. Extended protection of family status and the handicapped family status refers to the members of the family. The amendment prohibited discrimination given the people with children adjusting, living with the processes, acquiring legal custody. Anyone with an 18-year pregnant woman, physically, mentally handicapped, or also covered the handicap is defined with a mental or physical impairment that substantially limited the person's major life activities, including a person with records of impairment, currently drug addicts, and persons covered with a drug-related offenses. Transvestites are not protected with a handicap under the law with the alcohol cover. All appears as a protective restriction preventing the handicap from using necessary aids. For example, the person who requires seeing an eye dog should be allowed to have one if the pets are otherwise prohibited from the apartment building. Similar to that, the person would be allowed to take the dog through the hallway, even if the dogs are generally prohibited in public parts of the building. The pet owner can be required to repair the damage for the animal vacating the property. Discrimination in new construction. Under the 1988 amendment to newly constructed multi-family facilities, 4 or more units must be accessible to handicap in the building, and the elevator for handicap must have access to 100% of the units. Only ground floor units of the garden type of apartments are required to be accessible. Common areas of the building most accessible to handicapped person indoors. Hallways must be wide enough to allow passage of the wheelchair. New living units must be constructed in a way that allows access to the handicap, include appropriate locations, light switches, plugs, environmental control. Bathroom walls must be reinforced to allow full future installation. Grab rails, occupant must be allowed to install them. Handicapped person vacates may be required to restore the property in original condition. Discrimination in financing. Section 805 of the Fair Housing Act applies to the transactions after December 31st, 1968. States the laws for the following: any bank, building, a loan association, insurance company other than corporation, association, firm, enterprise, wherever the business consists wholly or in part of making commercial real estate loans, deny a loan or other financial assistance to a person applying therefore for the purpose of purchasing, constructing, improving, repairing, maintaining a dwelling, discriminating against him in the fixed amount of the interest rate, duration, other terms, conditions such as loan, other financial assistance because of the race, color, religion, sex, national origin of such person, and with any person associated with connection with such loan or other financial assistance purposes of the loan or some other financial assistance of the present, prospective owners and leases, tenants, occupants dwelling in the dwellings in relation to such loan financial assistance is to be made for the given and provide with nothing obtained and contained in this section should impair the scope of the effectiveness exemptions contained in section 803B. 803B exempt the single-family housing sale or lease by owner if certain provisions are met with the exemption described in page 404. Federal laws prohibit the leading institution redlining. Redlining is a practice whereby lenders designate certain areas too risky or refuse to make loans on the property in those areas. The term redlining refers to outlining of those areas on the red on the map before it's outlawed. Redlining by lenders usually affected low-income areas, particularly areas whose population were composed largely of minorities. Discrimination and brokerage services. Section 806 Fair Housing Act states that after December 31, 1968, it shall be unlawful to deny any person access to the membership to participate in multiple listings with real estate broker organization or other service organization facility relating to the business of selling, renting, dwelling, or to discriminate against him in the term and conditions such as access, membership, participation in an account, race, color, religion, sex, national origin, familial status, and handicap. Blockbusting is the solicitation of homeowners, unscrupulous real estate agents, brokers, and speculators who feed upon fears of homeowners prohibited by the Fair Housing Act. Blockbusters attempt to buy the properties at a very low price from whites and racial and transitional neighborhoods, and then the brokers sell them to the blacks at a higher price. Some blockbusters deliberately incite panic and white flight is to achieve the greedy, unlawful goal. Steering is a legal practice whereby real estates or salesperson show or do not show clients certain houses because of the client's race, ethnicity, in two principal forms. One, intentional failing shows the house for the certain neighborhoods based race, color, religion, sex, national origin, family status, and handicap. Two, showing clients only certain neighborhoods where their race, color, religion, sex, national origin, family status, and handicap is common. The practice of steering a violation of Federal Housing Act that sees the broker, salesperson, gatekeepers for exclusive neighborhoods determined to avoid with the discussion and advertising, but the practice is absolutely illegal steering. Other brokers may think for the provide valuable service that they may direct a client to certain neighborhoods where they believe the client will feel comfortable. Brokers and salespersons should show the client properties that are suitable for their needs without regard to race, color, and other protected categories. Exemptions. Fair Housing Act covers a single and multi-family dwelling units, and few of the exemptions below. The dwelling is defined with any building structure designed as a residence to be occupied with one or more families, including mobile home parks, trailer courts, condominiums, cooperative timeshare units, community associations, adult unit. Only communities are clearly included unless qualified under exemption. Housing with the elderly, only communities are built and operated with the older person. Specifically, 100% of the units must be occupied with the resident 62 years of age, and 80% of the units must be occupied by at least 1% age of 55 or older. Apartments must publish adhere policy demonstrate intent to serve the person age 55 or older. Apartment complex 4 or fewer units exempt of the Federal Housing Act. Owners occupy at least one unit. Single-family homes are rented by the owners exempt. However, the exemption applies only to persons owning more than their 3 properties at one time. Subject to other restrictions, selling the owner may not, real estate salesperson, broker may not print, publish, or otherwise make any reference, preference, limitation, discrimination based on race, color, religion, sex, national origin, family status, and handicap. Another exemption allows religious organizations to discriminate with respect to non-commercial property. It does not, however, allow exemption to religion discrimination based on color, race, color, sex, national origin, family status, familial status, handicap with respect to its membership. Another exemption allows private clubs to provide lodging as an incident to many purposes of the given and preferential treatment to club members. Or enforcement by federal government. Any person who claims to be injured with a discriminating housing practice believes that they will be irrevocably injured with a discriminating housing practice that was about through the hereof. The person aggrieved may file a complaint with the Secretary of the Department of Housing and Urban Development. Complaints must be in writing. Most state of the facts must be filed with 1 year alleged discrimination housing practice occurred with the Attorney General conducting the litigation. Secretary HUD participates in party pursuant to the Fair Housing Act. Enforcement of private person by private person when the rights guaranteed by private person by Fair Housing Act may be enforced in civil action appropriate to U.S. District Court without regard for the amount of controversy and appropriated state and local courts of the general jurisdiction. Civil action must be commenced within 1 year after the alleged discrimination housing practice occurred. Upon the application of the plaintiff, the circumstances of the court may deem just the court of the United States the civil action under this section has been brought by the appointment attorney for the plaintiff may be upon proper showing authorized commencement of civil action without payment of fees, costs, security, court of sale, subdivision, thereby due likewise extent with no not existence of the law of the procedure, state, and subdivision. The court may grant as a relief it deems appropriate permanent temporary injunction, temporary restraining order, or the order may award the plaintiff actual damage injunctive with the other equatable relief penalties up to $50,000, $100,000 for repeating violations. Together, the court costs and reasonable attorney fees in this case of the prevailing plaintiff provided the said plaintiff an opinion of the court and is not financially able to assume said attorney fees. Penalty, injury, intimidation, discrimination, under Section 901 Civil Rights Act 1968, Title 9, whoever injures, threatens, injures, interferes with any person with a race, religion, color, sex, national origin, family status, handicap, who is selling, leasing, occupying, financing, etc., dwelling, B. intimidates a person who deals with the other housing account, race, religion, color, sex, national origin, family status, handicap, or discussion other than dealing with other housing and account, race, religion, color, sex, national origin, family status, and handicap shall be defined $1,000 in prison up to 1 year or both, and bodily injury result of a penalty fine of $10,000 maximum up for 10-year prison or both. Death results and wrongdoer should be imprisoned for any terms of years or for life. Over the other fair housing laws, fair housing law was not first law intended to prevent discriminating practice of housing. 1866 Civil Rights Law barred racial discrimination in public-private housing. Supreme Court in the United States in 1970, the Buchan case prohibited constitutional grounds local governments were requiring residential segregation, thus ruling noteworthy because in 1896 the Supreme Court had established the doctrine was legally compelled segregation in such areas. Public transportation, public education was constitutionally permissible. The Buchan decision destroyed the doctrine as applied with the housing. In 1948, Shelley versus Kramer, Supreme Court struck down unconstitutional law enforcement racial restrictive governments. The executive branch of the government took the Housing Act for the first time in the 1962. President Kennedy issued the executive order Equal Opportunity in Housing, although represented a significant legal step forward. The executive order limited the guarantee with non-discriminate restricted largely housing provided through the insurance the guarantee program administered by the FAA with the sister agency Veteran Affairs. After the date of the order issued on November 20th, 1962, housing finance through the conventional loans was not covered by presidential order, which also left hundreds and thousands of existing housing units for the FHA and VA assistance mean for the non-discrimination mandate. In fact, barely 1% of the nation's housing was covered by President Kennedy's executive order. In 1964, Congress had the Title VI of the Civil Rights Act. In 1964, prohibited discrimination, any program activity receiving federal financing assistance among the principal programs effective in this law was low-rent public housing and program directed providing for housing for the poor urban level. Like President Kennedy, Executive Order Title VI exceeded the conventional finance housing. Also, the Federal Housing Veteran Fair Housing Executive Order covered less than 1% nation housing inventory subject to the non-discriminatory requirement of Title 6. 1968 Congress Title 8 of the Civil Rights Act. 1968 Federal Housing Law. This law described at the beginning of the chapter prohibited discriminating practice of real estate broker builders and mortgage lenders. 1968, 2 months after the enactment of Title 8, the Supreme Court of the United States landmarked the case Jones and Mayer ruled the 1860 civil rights laws passed on the authority of the 13th Amendment were outlawed, without which outlawed slavery, bars all racial discrimination, housing, private as well as public. A total of 90% of all U.S. housing is subject to fair housing law. Alright, the Americans with a Disability Act was passed in 1992, considerably broad with the scope of the society for the general and most accommodate person with a disability, men with a provision of additional discriminating employment and access to public service. However, some of the most pervasive problems facing disabled persons have necessarily been involved with the real estate building, the most barrier-prone part of the physical environment. Narrower doors, hallways, variation floor level to require negotiation status, built-in facilities higher with the wheelchair-bound. List of problems go on and on. But most new construction is made for the public in general. Almost everything except for the single-family housing must make the barrier-free stands of existing business, and 15 or more employees must eliminate physical barriers, prevent disabled workers, customers free of function in the marketplace. The requirement obviously requires considerable retrofitting existing real estate. That was chapter 20. Chapter 21, Truth in Lending Act.